Hey, John Mayfield, the real estate tech guy. Thank you so much for joining me on a little quick video live stream for my YouTube channel, and also going over to Facebook and Twitter, a couple of other spots. But gonna go over a couple of very quick real estate exam questions, and I have those on the board. So we are going to go over to the board right now. Take a look at these. They are real estate questions that you very well could see on the real estate examination. So I'm going to go through these questions with you on the board and make some notes and come back occasionally to the camera, but most of the time I'll be right on the board. And we have 5 quick questions that I think you will appreciate and should be ready for come exam day. So let's look at this first one. Tim bought a home from Bob and Sue. The owners agreed to owner finance the property. The parties agreed to amortize the loan over a 15-year period. The buyer became the owner of record of the property, and the seller had a lien against the property. What type of instrument was used to purchase the property? Well, a lot of interesting things going on here. And there's several things you need to pick up when you look at this question. First of all, who is Tim? Let's ask that question. Tim, he bought a home, right? So Tim's the buyer. Now, there is something given to us in the question down here that says the buyer, who is Tim, right, became the owner of record. Now, the owners agreed to owner finance, which is a purchase money mortgage right here. However, one of the questions says a land contract. Okay, let's take a look at that. So a land contract, we know, is owner financing. However, remember, with a land contract, this is why it's so important to know the definitions. With a land contract, the seller still retains title to the property. So if you go to the courthouse and you look up on the records who the owner is, it's going to show the seller. Because under a land contract, what we also call a contract for deed, the buyer has what is called equitable title, the right to get the title when they've made all of the payments. So if we go back to this question, the buyer in this case, Tim, he's the owner of legal record, so he doesn't have equitable title. Tim actually has legal title. So if Tim has legal title, the correct answer would be a purchase money mortgage, which is, anytime you see a purchase money mortgage, it's seller financing. So I went over questions a couple of days ago on the channel. I'd love for you to go back and watch that video because I break down distractors and stems. We can, and let's see if I can get my highlighter up. I don't know if I can get that up or not, but B is a distractor. It is partially true because a land contract is seller financing, but the key here is that Tim is the owner of record. And since Tim is the owner of record, that would void out a land contract. Because if it was a land contract or a contract for deed, Tim would only have an equitable right. Bob and Sue would still be the owners of record, okay? It's not a loan assumption because the owners financed it. And a reverse annuity mortgage, which, by the way, some people have seen on the exam, it's not that as well, because this is good for seniors, and that's, I think, how they're asking this on the exam. But a reverse annuity mortgage allows you to have money sent to you every month, and so your mortgage is going the wrong way and you're building up on your loan. So the correct answer in this scenario is C, a purchase money mortgage, seller financing. And the key here is because the buyer, Tim, became the owner of record. Okay, so kind of remember that. That's a very, very good question. So here's the second question I want us to go over. Jim signs a contract to purchase a house, but then attempts to have the contract voided. Jim is able to prove that he was legally mentally ill when he signed the contract. Will the buyer likely have the contract declared void? Now, Jim's the buyer, so I'm just kind of throwing these in to keep you in check with the question. But Jim signs a contract. He's able to prove that, hey, I'm legally mentally ill when I signed that contract. Will he be able to have the contract declared void? Let's look at the answers. Yes, because his mental illness renders the contract voidable. That looks pretty good, doesn't it? Let's read on. Yes, because any buyer can void a purchase agreement before closing. Well, we never talk about that. So remember in that video I gave you about learning to check the questions correctly, get rid of those that you know are wrong. No, because mental illness is unrelated to enforceability of contracts. No, because mental illness is unrelated to enforceability of contracts. Let's put a question mark there. No, because the contract was written and signed by both parties. Well, this one, we're really getting down to three questions here. And in this specific example, the correct answer is A, because his mental illness renders the contract voidable. A legally mentally ill person, if they sign the contract, could void that contract. Now, if you hear some snoring in the background, that is my little dog, Lucy, who's not far away. She loves to come downstairs when Dad works. And so I said I need to have a Lucy cam. Maybe in a moment, I'll take this camera here and we'll do a Lucy cam so you can see you can tell she's not into the real estate questions, is she? So anyway, no problem there. All right, let's go to the next question. The Real Estate Settlement Procedures Act, RESPA, applies to which of the following loans? Well, a 40-acre farm, contract for deed, an installment contract, or a first mortgage loan. Well, the answer is this. Now, you might be thrown, first of all, contract for deed. Remember, that's owner financing. And that's what we just talked about a minute ago with Bob and Sue, that we knew it couldn't be a contract for deed, because under this type of owner financing, in that example, Bob and Sue would be the, whoops, I'm spelling wrong here. Bob and Sue would be the legal owners. If you went to the courthouse, you would see their name, and the buyer only has what is called equitable, the right to get legal title when they've paid all of the payments. At that point, Bob and Sue have to sign the deed over to the buyer. But here's what's interesting. And again, this is why I tell students to know the definitions and terminology, because an installment contract and a contract for deed are the same thing. Okay, so we can cross those out. Now, you might be tripped up here wondering, what about this? Does RESPA apply to a 40-acre farm? No, it's 25 acres or less. Okay, so it doesn't apply to that. So the correct answer is a first mortgage. The next question, a buyer bought a house in a subdivision zoned residential. So it's zoned residential. The buyer wanted to open a daycare in the home. To do this, so legally, the buyer should obtain a, well, would it be a conditional use permit? Non-conforming? A bulk zoning permit? No, that one we don't even talk about. So that, remember, there's always a couple you can get rid of. A buffer zone? No, that's when a buffer zone is when you have residential and you have industrial or commercial over here. And so the city puts a buffer zone or like a park in between the residential and industrial. So it wouldn't be that. So we're down to A and B. And again, you got to know the terminology. A non-conforming use was there, and here's the key word I want you to write down. It was there before zoning existed. Okay? A conditional use, so it's not B, so the answer is A, which is a conditional use permit, which allows someone to deviate from the norm. Okay, so deviate from the norm. Last question. A property owner requests that the agent managing her apartment complex avoid advertising the units in a separate or in a specific local newspaper. So this is interesting because the property owner wants the agent managing her apartment complex to avoid advertising the units in a specific local newspaper as it's published by her ex-husband. Now we got fair housing and advertising and, what should we do here? Despite the agent's recommendation based on previous success with this newspaper's ads, the owner remains firm in her decision. Should the agent proceed with placing an ad in the newspaper? Well, let's look at the choices. Yes, because placing the ad would not be against the public interest. But you're going, remember, you owe care, obedience, get rid of that wasn't a good C. Obedience, accountability, loyalty, disclosure. Some instructors use old car, which is okay. So I don't know. I want to read on. Yes, because as an independent contractor, the agent has final say-so. Well, you have a fiduciary obligation. Remember, you have to do everything that is lawful. So you can't do anything, you have to be obedience right here is one I learned. You have to be obedient to all lawful instructions. So I'm going to get rid of B. No, because the agent must follow the owner's lawful instructions. Remember, the question is, should the agent proceed with placing an ad in this paper? Well, is there anything wrong with saying, I don't want to advertise in this paper because it's my ex-husband? Doesn't say anything in the question about it being a Spanish paper or a paper that is geared toward a specific culture or race. So I'm leaning towards C, but let's read all the question answers. No, because the owner has a contractual authority over the agent's actions related to rental advertising. No, because the owner has a contractual authority over the agent's actions. I don't think there's anything about this that we discussed in school. And so this, A, as we read through these, is incorrect. So the correct answer is C. All right, couple of quick reminders I would love for you to not forget. And this is important, I think, here. The Fair Housing Act prohibits discrimination based on race, color, national origin, religion, sex, familial status, and disability in all aspects of housing. While some small owner-occupied properties may be exempt from certain provisions, this is the key that I want you to write down. And I'm going to highlight this on the board. Discrimination in advertising is never allowed. They love these questions, and you have to ask yourself, well, I don't care. You know, we understand here, and this is the other key thing I want you to note. Race discrimination is always prohibited under the Civil Rights Act of 1866, with no exceptions. So you can never, even though you might be a small owner-occupied 1 to 4 family dwelling, and you don't want to rent to someone because of their familial status. If you're living in that property, that's one thing, and it's a 1 to 4 family. But you cannot advertise that you won't rent to people with children, okay? So you need to know this point right here very well, and you need to remember that discrimination is always prohibited under the Civil Rights Act. In all advertising for housing, it's illegal to make any statements that indicate a preference. Now, again, talking about advertising, limitation or discrimination based on race, color, national origin, religion, sex, familial status, or disability, even if a property qualifies for certain exemptions under the Fair Housing Act. Discriminatory language in ads is never permitted. All right? So do not forget that. Hey, I hope this was helpful. 5 quick questions that you could see on the real estate exam. Be sure and subscribe to the channel. I'd love for you to do that. And also, I have some free, recently seen exam questions. The link is down below. And also have the link here on my YouTube channel up above. They're free. I say they're recently seen. Sometimes birds will fly through the yard as I'm out in the yard. My phone rings and it's some little bird that's flying by asking me a question. So I tried to recreate at least the topic for you and prepare you for that. And they're absolutely free. Just go to the link down below and check it out. Hey, you can't beat that at Grandpa Pigeons, right? So thanks for watching. I hope you have a great day, and check us out at globalrealestateschool.com.